Scaffidi Show on WTMJ.
Spent a lot of time in the last couple of years on the show talking about the relationship between the governor's office and the legislature and all the issues we talked about, mask mandates and policy issues. Joining us on the phone line is former Wisconsin Supreme Court Justice Dan Kelly. Good morning.
Good morning, Steve. How are you?
Great to talk to you. It's been a while. So you are working or have completed a project for the Institute for Reforming Government. And as I pull this up, it's called the Lawmaker's Manual for Legislative Oversight. What was your mission statement here? What are you trying to accomplish?
Yeah, so this is a project a long time in coming, and the impetus for it really, I think, is we start with the people of Wisconsin and the things that get them frustrated. They see the governor or the bureaucrats doing things, and they wonder, is that actually consistent with the law? Or they see bureaucratic breakdowns, and they wonder, well, why did that happen? It couldn't be better. And the manual is written to help the legislators answer those questions. So, we all know that the Constitution places the legislative power in the legislature, and we think of that primarily as being the power to make law, right? But that's not the only thing that legislative power includes. It also includes the responsibility to track the law once it's been enacted to make sure that it's being honored and followed by the executive branch and by municipalities around the state. So when we see things that frustrate us, things like, MPS losing track of the educational status of over 20,000 students, or the Department of Health Services issuing a statewide stay-at-home order, or we see the governor issuing one emergency declaration after another when the statute does not give him authority to do that, or any of a number of other things that happen in the state, and we go, wait a minute, is that right? Is he supposed to be able to do that? Is that consistent with the law? The legislature's responsibility is to step in and say, we're going to figure that out. We're going to find out if that's right.
Why do you think we've gotten away from that standard where, as you just laid out, that's the way it's supposed to work? And obviously politics plays a role here.
Yeah, I think politics does play a part of it. I think most of the reason is because oversight's not easy. It's not an intuitive kind of thing. And until now, there hasn't been a tool that the legislature can use to help direct and guide its exercise of the oversight authority. So that's why we wrote the manual, is so that they have a step-by-step guide on how to do this. So I wrote the manual in 3 parts. The first part explains why it is so important to exercise oversight, to be a custodian of the law, to find out when things go wrong, why they went wrong, and figure out a way to fix it. So that's part 1. Part 2 provides the historical and constitutional authority for exercising this kind of power. And then part 3, the most extensive and I think probably the most helpful, is a step-by-step guide to doing this. And it starts with the methodology of conducting investigations and hearings. And then we just take them through the process of identifying the subjects in need of oversight, planning out and executing an investigation, and then planning out and executing a hearing that is not only designed to present the facts to the people of Wisconsin, but is also designed to drive towards an effective remedy to the problem they were addressing.
Former Wisconsin Supreme Court Justice Dan Kelly joining us on WTMJ. One of the big areas of concern has been the implementation of elections, how they've been conducted, the practices that the clerks are using, the Wisconsin Elections Commission. I would imagine that's an area where your ideas, your thoughts on legislative oversight would probably most clearly and with most relevance come into play.
Yeah, I think the manual is written to help the legislature address any issue on which oversight is necessary. But that's one in particular where we've seen over the last year people have got concerns about how the Wisconsin Election Commission conducted the election, and there are a number of issues there that could be productively examined. So, for example, the use of drop boxes. Is that something that's allowed by statute? Clerks filling in witness addresses on absentee ballot affidavits, whether that's appropriate. The use and administration of election-related grants in Green Bay, Milwaukee, and other places around the state, whether that's allowed by statute and whether it was done according to law. All of those kinds of issues can be thoroughly addressed through the exercise of the legislature's oversight authority. And the good news about this is this is not about partisan sniping. It's not about finger pointing. It's about getting to the bottom of the issue, figuring out what actually happened and why, and then driving to a solution. So I know that, in particular up in Green Bay, there was the mayor was invited to come and testify before the legislature, and he declined. And one of the things that we explain in the manual is, you can certainly make a request to have someone come and testify before the legislature, but you know what? A municipality is a political subdivision of the state. Political subdivision of the legislature exists because the legislature says it does. And when the legislature asks a mayor to come and testify, that's more than a simple invitation. That is, you need to be here. And if he declines, the manual explains how to use subpoenas to compel his attendance. So all the way from authorizing the subpoena to drafting it, to issuing it, to serving it, to enforcing it. So this is more than just a casual investigation. This is the manual just explains how to do an in-depth, thorough, official investigation that has subpoena power to back up what the legislature is doing. So you can really drive to a solution.
In all of this, the role of the governor, you mentioned one instance where you felt the governor overreached on health and safety measures related to the pandemic. What is the role of the governor here? How is it constitutionally defined in Wisconsin?
Yeah, so the governor is given the authority to execute the law, right? So, we oftentimes talk about our form of government, obviously in three branches. We often talk about them being co-equal. And in a sense, that's correct. They each have equal dignity. And what I mean by that is if the Constitution gives a certain authority to one branch of government, the other branches may not interfere with that. They may not exercise that power themselves. But when it comes to to the creation of public policy, the legislature is first amongst equals. And so what the executive does and what the courts do is largely derivative of the work of the legislature. So the governor's job is to execute the laws the legislature creates. The court's job, except for when it's applying constitutional or common law provisions, is to apply the laws that the legislature passes. So their work is derivative of what the legislature does, and that puts the legislature in the driver's seat. So in the question of whether, who leads in public policy, is it the legislature or the governor? It's clearly the legislature. So when we see the governor or an administrative agency going beyond what the law allows them to do, it is not only appropriate, it's essential that the legislature step in with its oversight authority and call them on the carpet for that.
My attorney friends always tell me that even in law, there's always room for interpretation. Is there room for interpretation in how these things are handled in the state of Wisconsin when it comes to the laws about elections or mandates or health and safety issues?
Yeah, so I think that there's something known as motivated reasoning, and perhaps you've heard of it, and that's when somebody has a conclusion they really like, and they kind of backfill in the rationale for doing that, and that happens in the law as well. As far as a straight-up, just objective analysis of the law and what the governor is allowed to do versus the legislature, I don't think there's really any question. There's no way you can reason yourself in a Aristotelian logical sense. You can't get to the governor having the leading role in creating public policy. He is there to execute the policy that the legislature creates. So now that's not to say he doesn't have discretion, right? Because oftentimes the law the legislature passes vests the governor with discretion in what he may do. But what the legislature may not do is just wholesale turn over to the executive the power to create the law. So, for example, last year, the Wisconsin Supreme Court considered the case, the Wisconsin legislature versus Palm, and that had to do with the statewide stay-at-home mandate.
Right.
And what we decided as a court was that the secretary could not do that as an order. She would have to go through the rulemaking process to create the authority to issue that kind of an order. Justice Rebecca Bradley and I wrote separately to emphasize the separation of powers question that presented. Right? So we looked at that statute, and the statute that the legislature drafted a long time ago, decades ago, said basically, if there's a pandemic, governor, you get to make the law. Just, whatever you want, you get to make the law. Mm-hmm. And that's a violation of the separation of powers. And I think it's a pretty clear violation of the separation of powers. And so we wrote about that and why it's so important for the legislature to remain the policy-making branch, because they're the ones that are directly accountable and regularly directly accountable to the people of Wisconsin. Assemblymen have 2-year terms. And the reason that they have such a short term is so that they are regularly answerable to the people of Wisconsin for the policies that they're promoting. So that's why that's one of the reasons why the legislature has to be the first amongst equals in creating our state's public policy, and why once they create the law, it's their responsibility, duty, and obligation to continue to oversee the execution of the law, to make sure that it's being done the way they intended, to see if there needs to be any changes, whether a program is completed its work and needs to be retired. All of these things the legislature needs to continually pursue.
Last thing for you, we're talking to former Wisconsin Supreme Court Justice Dan Kelly. I've used the term dysfunction to illustrate the relationship between the bodies of government in Wisconsin and the authorities. Would you use that term, or would you use a different term?
Well, I might use a different term. I like the way the founders described this, pitting ambition against ambition. Right? So the idea was not that the three branches of government would work like a well-oiled machine. In fact, they anticipated and designed it so that they would be butting heads, because what they didn't want to have happen is to have our government have runaway power and authority to govern our lives. They put these branches at odds with each other, so that each of the individual pieces of power would reside in the proper branches, and that they would not accumulate into one hand. So in fact, they said that the accumulation of executive and legislative authority in one hand is the very definition of tyranny. And that's why it's so important that we concentrate on maintaining this separation of powers, making sure the legislature is the only one making the law, making sure the governor does not, making sure that the judiciary simply applies the law as it exists and as it is written, and does not write the law. So these are the safeguards for our freedoms, is having these branches in tension with each other. So I think that's actually the way it was designed to work. It's not supposed to be efficient. It's not supposed to be easy to pass laws. It's supposed to result in a system in which only the needful laws are passed, where you can get agreement that a law is necessary to promote human flourishing in our communities all across the state. So I think that's part of the inherent design.
Maybe in layman's terms, a little friction sometimes is a good thing?
I think that's right.
I appreciate your wisdom and sharing it on the show today. Former Wisconsin Supreme Court Justice Dan Kelly. Always love to have you on the show.